Hi, folks. Welcome back to another episode of SQE One Window. We'll explore defamation and privacy in tort. You have heard about Trump suing, I believe, New York Times and many other media outlets for fake news, as he talks about. So, truth and fake news most of the time. I'll try to explore it in tort, and we'll try to just focus how it is examined in SQE. So the first thing is, this is the idea where law meets gossips, media headlines, and occasional celebrity meltdown. Defamation protects your reputation, not your feelings. That's what is the caveat we need to understand. It is not about how you feel. It is all about defamation and the way law defines it, and that is protection of reputation only. If someone calls you boring, the law will not help you. Even if it hurts, law will say, I have nothing to do with it. But if someone spreads a lie that makes others think less of you, that's where tort law steps in. Defamation comes into two flavors. Libel for statement in a permanent form like newspaper, blogs, or social media posts. And other form is slander for spoken words, the gossips. Usually transient and harder to prove most of the time because it was someone said it. The law here is all about balance. How do we protect reputation without crushing free speech? That's why That's why Parliament passed the Defamation Act 2013. Of course, sometimes Parliament becomes punishment when it comes to taxes. So it is Parliament, and they passed Defamation Act 2013 to bring some much needed common sense to a field that was once full of eccentric lawsuits. So, yes, you can sue for lies, but not for insult. The law protects character, not ego. You can say that, hey, you can't teach good. You can't teach us SQE1 at that point, and that's not defamation. Even my ego is hurt that I have done a lot to prepare these slides. So at that point, law will not protect me. So to understand elements of defamation, let's break down what a claimant must prove. First, defamatory meaning. The statement must lower the claimant in the eyes of right-thinking members of society. So not gossip, column readers, but reasonable people. So, for example, saying someone lied under oath or cheated client is defamatory. Saying they are terrible at cricket or football, not so much. You can say that you are a terrible teacher, or you can say you are a terrible person at that point on something like for example, I play tennis, but I'm terrible at tennis. If someone says you are terrible, at that point I can't take them to court in defamation. Second, identification. The statement must refer to the claimant by name, image, role, or clear implication. It does not have to name them directly. It's enough if some reasonable person can tell who is being referred to. Sometime in comedy, they change names at that point, but that's not a defamation. That is only for the sake of comedy. Third, publication. The statement must reach at least one third party. A private insult widespread into someone's ear is just rude, not defamatory. And now the most important modern requirement under Section 1 of Defamation Act 2013, serious harm. That's what we need to understand. For example, I'm irrelevant. No one knows me at that point. If nothing happened, that will be a different story. So the claimant must show that the statement has caused or is likely to cause serious harm to their reputation. For companies, it must cause serious financial losses. So next time, once you are talking about companies in review, be careful. This stops trivial claims, smaller claims. The court don't want to waste time on playground squabbles or social media exaggerations people do on social media. So in the SQE1 exam, always check for serious harm. It's the difference between strong claim and dismissed one. So the next thing is defenses to defamation. That is, of course, not every damaging statement is unlawful. Sometimes the truth hurts. Literally, it does. Let's go through main defenses. Truth, section 2. If what you said is true, you win. The defense applies even if you were unkind. Law protects accuracy, not politeness. Honest, that is section 3. That were you honest in your opinion? This covers expression of opinion rather than fact. If you genuinely believe what you said based on true fact, and it is recognizable as opinion, the defense applies. So a theater critic can say the play was dreadful. That's opinion, not defamation. Hey, your teaching is boring. That can be truth. So public interest is another thing that can protect us. This protects responsible journalism and public discussion. And key question was publication in public interest, and did the publisher reasonably believe what it was? Then we have privilege. About something is absolute privilege covers things said in parliament and in court. Total immunity, you cannot call these things in question. That's why sometimes parliament and public are asked to repeat what they said in parliament, and they don't. Qualified privilege applies to fair and accurate reporting, and as long as it is not malicious. For example, things told like you people have told to solicitors at that point, to doctors and all. And that is under law that they can't share it with people. While innocent, dissemination protects intermediaries like internet providers or news vendors who knowingly distribute defamatory material. They were innocent, they didn't know that it is defamatory. So for your SQE1 prep, remember, every defamation question is a tug of war between freedom of speech and protection of reputation. Your job is to find where fairness lies. Is it fair to say something or keep your mouth shut? So the next thing is privacy and misuse of private information. Now let's shift to privacy, a close but distinct cousin of defamation. Defamation protects your reputation. Privacy protects your dignity and personal life. The leading case is Campbell versus MGM Limited, where supermodel Naomi Campbell sued a newspaper for publishing photos of her leaving a narcotic anonymous meeting. The court said her drug treatment was a private matter, even though her public image was part of the story. So this case has given birth to the modern tort of misuse of private information. So the test has 2 stages. Step 1 or stage 1, did the claimant have a reasonable expectation of privacy? Think medical records, family life, or personal message. It is all private. That you can't take all medical data of Tom Cruise and make it public at that point. This will be breach of privacy. Stage 2, does the claimant's privacy outweigh the publisher's right to freedom of expression? And this is where Article 8 privacy and Article 10 expression of the ECHR face off. Typical Examples include leaked photos, personal health details, or information about children. The remedy is often an injunction or damages for distress. The courts are constantly balancing protecting individuals while allowing a free press, freedom of speech. So, if a tabloid prints a story about a celebrity's haircut, that's fine. If it prints details about their therapy sessions or medical records, that's crossing the line. So, let's go to our favorite SQE perspective of this topic. So, all right, let's talk about how to approach this topic in your SQE1. Step 1, identify the nature of claim. And at that step, is it about reputation or privacy? The distinction is crucial. That's what you need to understand. Number 2, apply the correct law. In defamation, it is Defamation Act 2013, and in privacy, it is Article 8 and 10 of ECHR. Step 3, access the balance. In privacy, it's the tug between freedom of speech and right to private life. In defamation, it is between reputation and honest expression. So the common pitfalls that you need to avoid, and we give it in every discussion, and that is confusing opinion with fact, forgetting the publication requirement, ignoring the serious harm threshold, treating privacy and defamation as the same tort. That's not. Your golden SQE question: has the law struck a fair balance between free expression and the claimant's right to dignity or reputation? That's the heart of every exam question on this topic. And one more practical tip: if you are ever tempted to tweet something spicy, imagine reading it loud in court. If it sounds risky, it is risky. Careful. Thank you very much for joining us today, and I hope it makes sense. You can further improve your knowledge from our notes and test it with question banks. Wish you all the best.